Hi everyone, in this week's dispatch video we're talking about restrictive covenants, so post-termination restrictions which are often contained in more senior employees' contracts of employment. Now the case does arguably conflict with one of the basic principles, which is that the covenant when drafted must go no further than is absolutely necessary to protect the legitimate interests of the employer. If it's drafted too widely, the court has an easy argument to strike down the clause as a restraint of trade, and the business will lose the protection of the restrictions either in part or altogether. Now, we do have some case law which is fairly pro-employer and which has reached the Court of Appeal, and that focuses on the High Court's decision at a lower level to strike out part of a restrictive covenant which had the effect of keeping the remainder of the content valid and therefore enforceable by the company. So in this particular case, there was a doctor who worked as a head of commercial in a very niche pharmaceutical business. He resigned and said he was going to work for his employer's main competitor, and the employer sought injunctive relief. So they said, hang on, we have a restrictive covenant which prevents you from working for that direct competitor for a period of 12 months. You can't go off and do that. We're going to go to the court and get an order which essentially forces you to remain away from that competing business. Now, the 12-month non-compete clause in the contract prevented him from being involved in any activity for the benefit of any third party that carried out any business which would compete not only with his employer, but any employer in the group as well. Now, when that reached the High Court, they said actually to extend that restriction to any group companies is too wide and it would be unenforceable, because those other group companies focused in pharmaceutical areas that the employee had no experience in, no interest in, and really couldn't harm his business if he moved into areas which competed with those group companies. So the court strikes down part of the clause, but says actually the clause preventing you from working for the direct competitor remains enforceable. So the employee appeals and says, actually, you can't do that. If you strike out part of the clause, it fundamentally alters the nature of that restriction. And in any event, even if you did strike out part of the clause, a 12-month non-compete restriction is unenforceable. It's too restrictive in the circumstances. Now, on the first point, there is some case law around removing elements of a restriction to keep it valid and binding. There is a principle that essentially confirms that where the drafting gives a fantastical, extravagant, improbable or unlikely consequence that was not within the parties' contemplation when the contract was signed, that element of the restriction can be removed and it can be kept alive. So we have the direct employer, which is involved in very specialist activities. The court said it was never intended when the parties signed up to the contract that the restriction was meant to affect other group companies as well. They said it was fantastical and extravagant that was a consequence, and it was never intended by the parties. So the court in those circumstances was entitled to amend the restriction and essentially allow the remainder to stand. The second argument failed as well. So the court said, well, actually, in some cases, a 12-month non-compete restriction will be too strong. It will be too onerous on the employee. In this case, having assessed the facts, that was just not the case. So it's of some comfort to employers who may have some drafting deficiencies in restrictions. In my view, it also creates more uncertainty. So when we are analysing clauses on behalf of either employee or employer, we can give a view on enforceability and say there are these defects, there are these challenges that we can raise. But the case law is clear in that it is always open to a judge in certain circumstances to look to strike out part of the restrictions in order to keep the remainder valid and binding. This is a very complex area of law. If you do need further advice on it, then please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.